Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-Immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Y'all, the circuits went ham this week, with even a former Supreme Court justice getting in on the action. I will do my best to guide you through the madness. Before I do, reach out to your DOJ or heck, US government friends. They are not okay. It seems like the purge is very much underway, and in the immigration world, we may be welcoming former government colleagues into our private ranks very soon for no other reason other than the fact that they were hired less than 2 years ago and so are in their probationary period. Surely others will be fired soon too, beyond their probationary period. It's already happening. Lives are being wrecked in the United States and all over the world. Individuals and families that made sacrifices and changed their entire lives to serve the United States are having the rug pulled out from under them because 2 billionaires think that government is stupid. Again, to all the law students and federal employees who are having their lives completely upended, I am one of you in spirit and wish that there was more I could do. Stay strong and reach out if you like. 8 cases. 8. Mark them. Here we go. Don't mind the baby in the background. Our first case is Lapadat et al. V. Bondi, published by the Ninth Circuit on February 12, 2025. This case is about asylum and past persecution. Judge N. Randy Smith dissented. The Ninth Circuit majority begins its decision by stating, about the BIA, that, quote, judges are human, and like all humans, they sometimes make mistakes, end quote. Wonder which way this one's gonna go. The Ninth Circuit uses first names to refer to the non-citizens, so I will too. The case regards Ion, the husband, his wife, Simona, and their 3 children, all of whom are Roma from Romania. Ironically, subjected to historic harms, even in the country that, it would appear, may be named for them. Quote, the Roma, commonly and derogatively known as gypsies, are Europe's largest ethnic minority, identifiable by their darker complexions, historically, nomadic lifestyle, and characteristic mode of dress, end quote. After living between Romania and France, the family came to the United States, and, once placed in removal proceedings, applied for asylum. Ion, the father, is the lead applicant with the primary story. The whole family was found credible, at least all of them who testified. The merits hearing lasted multiple days. The worst event appears to have occurred against Ion when in 2007, while collecting firewood on land that he thought belonged to the city, was cursed at by a man who called him a gypsy and other bad names, and then shot him in the back and in the skull with a shotgun as he, quote, tried to flee in his horse-drawn cart, end quote. Quote, bleeding profusely, Ion rushed to the hospital, only for the police to take him in for questioning before he could receive treatment. Once he told the police who shot him, they refused to take his story, threatened to imprison him if he tried to press charges, and left him to find his own way home. As it turns out, the police knew the shooter. Ion luckily made it back to his family, changed his blood-soaked shirt, and returned to the hospital, where a doctor discharged him, casually remarking that he was not going to die from this, end quote. He still has bullet shards in his body to this day, apparently. And actually, the mother and the daughter have pretty terrible stories, too. Two of the daughters were almost kidnapped and raped by Romanian men when they were very young, and they were regularly harassed and assaulted at school by men. The mother was slashed in the back with a knife and threatened with rape and murder when she tried to intervene at least one time. A few days later, men came to their home and tried to break in, threatening to rape the mother and children if the mother filed a police complaint. Looks like they tried to get police involved anyway, who, quote, didn't believe them, end quote, and indicated that they had no problem with the assaults. Quote, that testimony was just the tip of the iceberg, end quote. And as a very long decision in a very long week, we don't have time for all of it. Suffice it to say, it's bad. Much of it involving Romanian police. The Ninth Circuit goes on to say, in a quote very important for all Roma cases, quote, the Lapadat's testimony reflects the experiences of many Romani people living in Europe and Romania. The Roma have been marginalized and vilified throughout Europe for centuries and are frequently derided as swindlers, petty criminals, and scum. According to the European Union, anti-Roma discrimination continues to be widespread across the EU and is present in all societies and in all key areas, end quote. And Romania is no exception. Lots of country condition evidence discussed in this decision as fact that should be reviewed and cited in all Roma asylum cases, no matter the European country, it would seem, and no matter the circuit. But an immigration judge denied and the BIA affirmed. The Ninth Circuit focused primarily on the BIA's decision here, which had held pertinently that the harm Ion and the other family members suffered wasn't actually bad enough to be persecution. Nor did the BIA believe that the Roma are a disfavored group in Romania, quote, given the EU's steps to combat anti-Roma sentiment in Europe through its framework, end quote, to deal with the historic Roma discrimination. The Ninth Circuit did not agree. Starting, by the way, by noting that the Ninth Circuit's past persecution standard of review is all over the place and unresolved. So heck, folks, keep arguing that it's a mixed question of law that is past persecution, and argue for de novo review. Importantly, quote, because the IJ found Ion, Simona, and Laura, the daughter, credible, their statements must be taken as true, end quote. And I mean, heck, Ion testified to getting shot in the back and skull, while his wife and daughters testified to multiple threatened rapes and other harms. So yes, to the harm Ion suffered. For quite some time in the Ninth Circuit, quote, physical violence is often a significant consideration to a past persecution analysis, and when we have granted, that is the Ninth Circuit, petitions for review because the record compelled a finding of past persecution, we have frequently done so because the petitioner experienced serious physical violence, end quote. And again, Ion was shot in the skull, something the BIA didn't even mention in affirming the no past persecution finding. The IJ, for its part, dismissed the event as, I suppose, a natural thing to happen for alleged trespassing, also calling the incident isolated, and mentioning that Ion was simply shot at. But no, explained the Ninth Circuit, not shot at, shot. And as Ion credibly testified, he did not believe that he had been trespassing. And the IJ knew that Ion was shot. Quote, pretending otherwise or minimizing it is not supported by substantial evidence, end quote. Oof. So too did the IJ err in characterizing the attempted kidnapping of the daughters as, quote, an abhorrent but not persecutory crime under Ninth Circuit precedent, end quote. That's not right at all. Attempted kidnapping and rape and death threats are clearly persecution under Ninth Circuit precedent, explains the court, particularly when it's an ongoing pattern. Lots of precedents cited too, including Carr v. Wilkinson, episode 40, which I must admit I knew was coming. Some cases just stick with you after 251 weeks. Nor was it isolated, as the IJ believed. Quote, far from it, end quote. Although even if they were isolated incidents, it would still be sufficient, notes the Ninth Circuit in a footnote. But again, it wasn't. Quote, the Lapadats, like many Romani people, had been mistreated by the police and Romanian public for years because of their ethnicity, end quote. Remember it. And remember this, quote, Ion testified to repeated harassment and beatings by Romanian police and his inability to secure meaningful or formal employment, basic health care, or public services. And both he and his family recounted the death, rape, and arson threats that they have endured. Such pernicious maltreatment clearly satisfies the past persecution criteria established in our case law, end quote. Nor need harm create, quote, lasting injuries, end quote, to be persecution under Ninth Circuit precedent. Although again, the guy has shrapnel in his head and skull, and his wife cries just thinking about their experiences, so it does appear that there are lasting injuries here. So a remand for the BIA and I guess the IJ to determine whether this harm, sufficiently bad, was on account of a protected ground and committed by the Romanian government or entities that it is unable or unwilling to control. Although in a footnote, the Ninth Circuit sure seems to think that the first prong of those two is met here. That's on the past persecution. But wait, there's more! I told you it was a long decision. If the family suffered past persecution, they get a rebuttable presumption that they have a well-founded fear of future persecution and so will likely win. But even without that, of course, an asylum applicant can win by showing that they have an objectively reasonable, well-founded fear of future persecution if returned to their country. The BIA held that that wasn't met here either, but the Ninth Circuit doesn't really agree with that either. See, in the Ninth Circuit, and even without a past persecution showing, quote, an asylum applicant demonstrates a well-founded fear of future persecution in either of two ways. One, by showing a pattern or practice of persecution for similarly situated people, or two, by demonstrating that he is a member of a disfavored group and is likely to be targeted as a member of that group, end quote. To me, that second thing is kind of close to pattern or practice, but it's not the same. And Ion apparently chose the latter here, and the Ninth Circuit saw a claim. After all, quote, the more serious and widespread the threat of persecution to the group, the less individualized the threat of persecution needs to be, end quote, to get a well-founded fear finding. To be clear, quote, Roma are a disfavored group in Romania, end quote, flat out. Read the decision to see what the analysis looks like, but it's pretty intuitive. And the court goes through recent Roma history to explain why they're particular here. Indeed, quote, today's rhetoric against the Roma is very similar to the one used by Nazis and fascists before the mass killings started in the 30s and 40s, end quote. Did I mention this is a must-read for Roma asylum claims? Lots and lots of country condition evidence for Romanian Romas specifically, too. Now, the BIA recognized most of this country condition evidence, but then kind of discounted it because the EU has been attempting to address Roma issues. A curious analysis when the focus should be on Romania, right? Quote, by doing so, the BIA appears to adopt the view that we analyze whether a group is disfavored from the perspective of supranational organizations and not national governments. That approach distorts our precedent, end quote. The EU isn't a government, folks, and we don't remove non-citizens to the EU, explains the Ninth Circuit. Having botched the disfavored group analysis, the Ninth Circuit notes that Ion should probably win, even without past persecution. After all, quote, when as here, a petitioner presents egregious evidence of group persecution, he can provide less evidence of individualized persecution to meet the objective prong of a well-founded fear showing, end quote. Absolute monster of a decision, particularly but not exclusively for Roma asylum-type cases. Before leaving the majority, I just wanted to note that the Ninth Circuit begins its analysis by stating, possibly cognizant of its critics and certainly the dissent, that, quote, at base, our opinion today does little more than accomplish Congress's goal when it passed the Refugee Act of 1980. We give proper deference to the BIA's analysis and correct its clear missteps, thus preserving our nation's systematic procedures for admitting refugees who have been persecuted in their countries of origin, end quote. As I mentioned, Judge N. Randy Smith dissented, going through his own view of the record and relying often on standards of review. But the case is going back in a big way. Meaning, congratulations Colin B. Desitnik for petitioners. And that is Lapadat et al. V. Bondi. That was a big heady one, right? Let's take a short break with Perez-Perez et al. V. Bondi, published by the Ninth Circuit on February 10th, 2025. This is a very strange and short one, but it's quite unique. And regardless, I do all the published immigration decisions, right? I have no choice. Mr. Perez-Perez, his spouse, and their minor children are asylum seekers from Guatemala. In an unpublished decision, published non-precedentially the same day as this published one, the Ninth Circuit actually denies their petition for review, meaning that this family lost. This published case here is all about procedure. See, Oil didn't want the wife and children to be part of this petition for review at all, because in the petition for review title, filed by the lead asylum applicant, Mr. Perez-Perez, the attorney, presumably, did not list the names of the spouse or the children in the caption. Instead, the attorney simply included their alien registration numbers. Does that comply with Federal Rule of Appellate Procedure 15A2A? Inquiring minds want to know. It does. The Ninth Circuit has said so many times in unpublished decisions, for example. Now true, FRAP 15A2A does preclude using terms like et al. Or just petitioners or respondents generally in the caption. You gotta identify who the petitioners are in a petition for review. But, quote, the Supreme Court has also explained that the procedural requirements of a complaint derive from the need to provide fair notice of what the plaintiff's claim is and the grounds upon which it rests, end quote. So, with that guidance in mind, should derivative non-citizens, or I don't know, even all of them, be subjected to a final order of removal without federal court review for failing to comply with an appellate rule where they're still identifiable by their A number? No, said the Ninth Circuit. Importantly, quote, these A numbers are not generic terms referencing unknown and potentially unidentifiable individuals, such as the procedural titles listed in the text of Rule 15, but rather correspond to specific persons who have raised claims before the agency for adjudication and whose names are readily available in the government's own records, end quote. Good enough, said the Ninth Circuit. Strangest case of the year. But again, in an unpublished decision on the merits, the family did lose. But while we're with this very short Ninth Circuit decision, let it be known that the Ninth Circuit amended its Kalulu v. Garland decision from episode 203, now v. Bondi. Judge Van Dyke still authored the majority opinion, affirming the adverse credibility finding, but remanding nevertheless to see if Ms. Kalulu's past persecution claim could still be proven from other documents in evidence. Judge Sanchez still concurred and dissented. And it's still a pretty big holding. Not least of which because it's a remand from Judge Van Dyke in the immigration context, but also, it seems that the Ninth Circuit is saying that adverse credibility is not necessarily fatal to an asylum claim. Pretty wild case, if I recall. Check out episode 203 for a refresher, and make sure that you're citing to this amended decision. That is Kalulu v. Bondi. But all of that was an aside. What you just really heard was Perez-Perez et al. V. Bondi. All right, friends, time to wrap up the Ninth Circuit's trio of cases this week. This is Murillo-Chavez v. Bondi, published by the Ninth on February 13th, 2025. This case is about firearms offenses, and in particular, the antique firearms exception. Been a minute. And it's about LPR cancellation of removal, and it's about crimes involving moral turpitude, and it's about ineffective assistance of counsel. Mr. Murillo is from Mexico and came to the United States as a child, I suppose, alone, because he received special immigrant juvenile status in 2010 and became a lawful permanent resident in 2011. But he messed up, and 5 years later pled no contest to unlawful possession of a firearm in violation of Oregon Revised Statute Section 166.250. Then in 2018, he was convicted of 2 more crimes. First, unlawful use of a weapon in violation of Section 166.2201A in Oregon, for which he received a 10-month sentence of incarceration. And 2, he was convicted of first-degree criminal mistreatment in violation of Oregon Revised Statute Section 163.205, for which he was sentenced to 31 months, committed in July 2017 and January 2018, respectively. So, DHS initiated removal proceedings, charging Mr. Murillo as removable under INA Section 237A2C, a non-citizen convicted of a firearms offense, and INA Section 237A2A a non-citizen convicted of 2 or more CIMTs not arising out of a single scheme of criminal conduct. Perhaps oddly, only the CIMT thing will bar an LPR from LPR cancellation of removal under INA Section 248A. And only if committed within 7 years of admission, because then it would trigger the stop time rule, meaning that Mr. Murillo wouldn't have the 7 years in any lawful status required of the LPR cancellation statute. An IJ ordered Mr. Murillo removed and barred from cancellation, and the BIA affirmed. And then it denied an ineffective assistance of counsel-based motion to reopen. The Ninth Circuit affirmed. Heady crimmigration decision with multiple issues, so strap in. Pull over your vehicle to the side of the road and sit there. Then strap yourself in and do not move. I am not responsible for what happens next. Actually, removability isn't really at issue at all, per se. That was part of the ineffective assistance of counsel claim. Mr. Murillo's attorney's failure to adequately argue removability where, according to new counsel, Mr. Murillo wasn't actually removable. The inquiry, however, is the same. Because to show ineffective assistance and potentially win on a motion to reopen, a non-citizen must establish prejudice, which here is going to require some sort of showing that Mr. Murillo wasn't or probably wasn't actually removable on the record. So then turning to the firearms offense first. The most common argument for such offenses was made here, that the Oregon law at issue prohibits conduct involving antique firearms, but, quote, in contrast, the federal definition of a firearm excludes antiques, end quote. You can technically be convicted of possessing an old musket or something in Oregon, while you can't under federal law, for example, depending on the age of the musket. Meaning that the Oregon statute is overbroad vis-a-vis a federal firearms offense. It covers more conduct. And that means that Mr. Murillo is not removable for the Oregon offense. Unless, of course, what the non-citizen possesses in Oregon is an element of the offense that the prosecution must prove, rather than merely a means of committing the crime, such that an IJ is permitted to look and see what Mr. Murillo was convicted of actually doing and see that, no, he did not possess 19th century weaponry. The statute is divisible, said the Ninth Circuit. And looking at the documents, Mr. Murillo did not have Civil War-era explosives. This is because the various statutory subsections are written separately in the disjunctive, and Oregon state courts have treated the different ways of committing the Oregon offense as separate crimes, that is, the different things that one possesses. Although the subsections all seem to have the same punishment, and while that could indicate indivisibility, it doesn't necessarily. And so importantly, not all subsections of Section 166.250 apply to antique firearms. Therefore, looking to the documents again, the Ninth Circuit saw that Mr. Murillo was convicted of subsection 1B, which does not permit conviction for possessing Napoleonic-era artillery. Which means that even though the first attorney didn't make the antique firearms argument, he wouldn't have won the day anyway, so no prejudice, so no ineffective assistance of counsel. Okay, so he's removable. And that means that the Ninth Circuit actually didn't have to discuss the 2 or more CIMT thing, because it's not relevant. You only need one reason to be removable. All that matters is whether one of the crimes was a CIMT committed within 7 years of Mr. Murillo obtaining some lawful immigration status, such that he's barred from LPR cancellation of removal. Diving deeper, the reason for all this is because, among other things, LPR cancellation of removal at INA Section 248A requires a showing that the LPR has, quote, resided in the United States continuously for 7 years after having been admitted in any status, end quote. But commission of a CIMT and some other offenses will stop the time from counting, under the law, if not in fact, committing one of the crimes. This case actually presents what could possibly be a pretty absurd scenario. See, Mr. Murillo argued that the time should begin counting on August 31st, 2010, when he obtained SIJ status. And Mr. Murillo's new counsel argued that prior counsel was ineffective by failing to point to documents that showed that the first of the two alleged CIMTs was committed on September 1st, 2017. So literally 1 day over the 7 years required. But a very meaningful 1 day. And seemingly correct too, except for one thing. The BIA held that the 7 years started when Mr. Murillo obtained LPR status the next year, not when he obtained SIJ status. And the Ninth Circuit agreed. Don't be fooled. The 7 years requires admission in any immigration status, so time spent continuously in non-immigrant status, for example, should cut it. But after inspection and admission, that is. Remember the statute's text? Mr. Murillo, in contrast, entered without authorization as a child, and while there are times where an inspection and an admission can actually occur inside the United States, SIJ status is simply, quote, a form of parole that confers eligibility for adjustment to LPR status to non-citizen minors who have been abused, abandoned, or neglected, end quote. Inspected, but not admitted, it would seem. But wait, argued Mr. Murillo. The Ninth Circuit literally said that SIJ status qualified as being, quote, admitted in any status, end quote, in Garcia v. Holder from 2011. Hold on to your horses, everybody. Garcia is no longer good law, explained the Ninth Circuit. Because Garcia in turn relied on the Ninth Circuit's 2006 decision, Garcia-Quintero v. Holder, which had held that acceptance into the family unity program conferred a similar status. But then in Sanchez v. Mayorkas, episode 59, the Supreme Court held that TPS is not an admission. Okay, definitely not directly on point there. But then in Hernandez v. Garland, episode 114, the Ninth Circuit held that Sanchez, quote, effectively overruled, end quote, Garcia-Quintero, which in turn, the Ninth Circuit panel is now holding, effectively overrules Garcia, the SIJ case. Quite the roundabout way to permit a panel to overrule another panel, methinks. But the logic's sound. And remember that logic is fair game. Dare I say, for Loper-Bright purposes. Get to that in a sec. Anyway, post-Sanchez, what matters is the definition of admission as used at INA section 101A13A. And to the court, like TPS and FRAP benefits received inside the United States, SIJ status does not cut it as admitted in any status to permit the 7 years from beginning to accrue for LPR cancellation of removal purposes. All of this means that if the first-degree criminal mistreatment offense is a CIMT, Mr. Murillo is barred from LPR cancellation because he doesn't have the 7 years, because remember, we're now counting from when he received LPR status the next year. And so, we come to the final portion of this monster-complicated treatise of a decision. CIMTs. And oh mama, here we come with Loper-Bright. Seems like this Ninth Circuit panel believes that it's largely a new day when it comes to CIMT adjudication. But quote, after Loper-Bright, those prior cases that relied on the Chevron framework are still subject to statutory stare decisis despite our change in interpretive methodology, end quote. Quoting Loper-Bright, of course. I guess. I truly believe that read in context, the Supreme Court must have been talking about its own precedent and not the circuit's. Heck, the Ninth Circuit here just went through pages and pages about how consequential Supreme Court decisions, like Sanchez v. Mayorkas, can and do implicitly overrule circuit precedent, even when they're nowhere near directly on point. How is Loper-Bright possibly not such a case? Then again, the Ninth Circuit does seem to be reading all of this a bit narrowly. Even if stare decisis applies, explains the court, it only applies to the determination that, quote, the specific agency actions are lawful, end quote. Those decisions, quote, were not overruled by Loper-Bright simply because they relied on Chevron, end quote. So it seems that if the Ninth Circuit affirmed the BIA's CIMT finding about a specific state's statute, for example, by relying on Chevron deference, that remains good law as to that specific statute. But the overall CIMT framework and applying that to another statute? I don't think so. And certainly not here, where the Ninth Circuit has never addressed this specific Oregon statute. So, is it a CIMT? It is. The Ninth Circuit says that its definition of a CIMT is pretty identical to the BIA's, so Loper-Bright really didn't affect that much. There are two types of crimes that can be CIMTs. Quote, those involving either fraud or base, vile, and depraved conduct that shocks the public conscience. End quote. For the second type, they, quote, will almost always involve an intent to injure someone, an actual injury, or a protected class of victims. End quote. So, like, theft crimes aren't CIMTs then? Ever? Right? Not fraud, not harm, not protected classes of victims, right? In the Ninth Circuit? Never? Argue it. But the CIMT definition was met here because the Oregon subsection at issue applies to defendants who, quote, fail to provide for a dependent's most basic needs for safety and survival, and only covers cruel deprivations, end quote, and similar conduct, apparently. That's a protected class of victims, dependents. Rejecting some other arguments, the Ninth Circuit denied the motion to reopen and remand because there was no prejudice, because again, he was removable for the firearm thing, and he was barred from LPR cancellation of removal because of when the stop time rule starts, and because the relevant crime is a CIMT. I am exhausted. But one more thing. That Loper-Bright stuff is important. Given how long and complicated this decision was, I didn't say it mid-case, but this quote here seems important. Indeed, it seems to me the most important post-Loper-Bright quote out there on immigration to date, so I'll read it in full, notwithstanding how long this episode and case is. Quote, given Loper-Bright's clear instruction that we otherwise need no longer defer to the agency's interpretation, we take the Supreme Court to mean that although the holdings of our prior cases in which Chevron deference was applied remain precedential until overruled, we are not compelled to use them as analytical building blocks in every case to determine whether the BIA correctly found in the case before us that a previously untreated crime is a CIMT. Rather, although the logic and reasoning in our prior decisions that relied on Chevron may aid us in determining whether a crime we have not previously confronted is a CIMT, just as we may be persuaded by the agency's analysis in the case before us, in the end we must exercise our independent judgment in deciding the present case. End quote. That's not limited to CIMTs either. All ambiguous phrases under the INA. If a circuit hasn't ruled on your specific statute or your specific scenario, in your specific context, the circuit is not bound by a similar precedential decision on a similar but not identical issue that had relied on Chevron deference, even if very similar. Keep making the argument. And heck, keep arguing against the underlying framework previously deferred to, be it CIMT, particularly serious crimes, particular social group, or others. And even make the arguments when the circuit has indeed addressed your very statute by relying on Chevron deference in the past. While you should lose if you do that latter thing, the Ninth Circuit seems to have included, quote, until overruled, end quote, quite purposefully in the quote that I just read. We're playing for en banc rehearing in some of these cases, folks. Or, I suppose, further clarification from the next panel. Don't leave me yet, guys. The episode's just getting started. And that is Murillo-Chavez v. Bondi. All right. Next is Acombe v. Bondi, published by the Fifth Circuit on February 12, 2025. This case is about continuances and motions to remand. Mr. Acombe is from Cameroon. He entered the United States on what appears to be a tourist visa in 1989 and has been here ever since, over 35 years, as old as Taylor Swift. Apparently he's had a long and complicated immigration history as well. As relevant here during this week of many cases, he tried to adjust through a spouse in the early 1990s, but that marriage ended. And then he also pled guilty to attempted rape and sexual assault in 1993 and was ordered deported in 1994.
Remaining in the United States, his convictions were later overturned, and his deportation proceedings were, quote, terminated in 2006, end quote, whatever that means. But removal proceedings were reinitiated in 2009 because, after all, he didn't have immigration authorization to be in the United States. He applied for non-LPR cancellation of removal in those proceedings, and he also married another U.S. citizen who filed a Form I-130 petition for him. Pertinently, an immigration judge granted Mr. Combe multiple continuances to let that process play out before USCIS. Continuances only necessary because, for some reason, immigration law inexplicably doesn't permit IJs to grant I-130 petitions, even though IJs can grant Form I-485 adjustment of status applications, the actual merits application. In any event, though, USCIS approved that I-130 petition, finally. So Mr. Combe pursued adjustment of status in immigration court, and it looks like the court set a merits hearing. But then his U.S. citizen daughter, who had turned 21 years old 10 months prior, filed her own I-130 petition for Mr. Combe, and 8 days before the hearing, he sought another continuance to allow that process to play out. Didn't make sense to the IJ. You only need one immediate relative immigrant visa petition to adjust to LPR status, so the IJ denied a continuance. Well, at the hearing that occurred 8 days later, we learned that Mr. Combe and his wife were having marital issues, and she didn't show up to the merits hearing. Hence the attempt for another I-130 petition. The IJ denied the continuance again at the merits hearing, and then the IJ denied adjustment of status. The petitioning spouse, after all, wasn't there, and there wasn't any approved petition. But again, of course, if immigration law didn't arbitrarily bar IJs from granting I-130s, the immigration judge could very easily have ascertained that Mr. Combe's daughter was indeed his daughter, a U.S. citizen, and over 21 years old, and proceeded to decide the discretionary adjustment of status application rather than ordering Mr. Combe removed based on kind of a technicality, bureaucratic process type thing. I believe all of this could be fixed and become much more efficient for all parties involved through a simple regulation. But again, although IJs have very important authority, they don't have this authority, so Mr. Combe was indeed ordered removed. Cancellation of removal denied, too. The BIA affirmed. Despite the fact that during the BIA appeal, USCIS approved the daughter's I-130. The BIA denied a related motion to remand. What are we doing here? The Fifth Circuit affirmed. First, it held that it lacked jurisdiction to review the IJ's denial of a continuance. Patel problem. Essentially, as we know, adjustment of status is a discretionary form of relief subject to the jurisdiction divesting statute that was adjudicated in Patel. So is cancellation of removal. And that statute, INA Section 242A2BI, strips circuit court jurisdiction over, quote, decisions relating to the granting or denying, end quote, of adjustment of status and cancellation of removal and certain other reliefs. So reasoned the Fifth Circuit, quote, a decision to continue a cancellation of removal proceeding relates to that proceeding, end quote. No jurisdiction to review the denial of a continuance. But on the other hand, the Supreme Court's Wilkinson decision saves jurisdiction in such cases where what's at issue is a mixed question of law and fact. And indeed, continuances are subject to a standard, just like the hardship standard for cancellation of removal adjudicated in Wilkinson. It's a good cause standard to grant or deny a continuance. But to the Fifth Circuit, that standard is not like the exceptional and extremely unusual hardship standard at issue in Wilkinson. Good cause is mushy, and, quote, has discretion baked into it, end quote. A mushy baking, then, I suppose. It's just too standardless that is good cause, and requires consideration of far too many things. The Fifth Circuit said it can't review it. Well, I suppose it is a mixed question of law and fact. It's not mixed enough, I guess. A bit unclear to me. But no jurisdiction, said the court, and that's a pretty consequential holding. And in so holding, the panel resolved the issue left open in Cuenca Arroyo v. Garland, episode 243, aligning with the view discussed a bit by Chief Judge Elrod in concurrence in that decision. Now recall, Mr. Combe had also requested a remand to pursue adjustment of status through the daughter once USCIS approved the I-130 while on appeal. But, going to the merits of that dispute, Instead of issuing another consequential, jurisdictionally barring ruling, the court held simply that the BIA wasn't completely out of bounds to hold that Mr. Combe did not act with diligence in the filing of his daughter's I-130, and so he's not due a remand. That is, he should have, I suppose, forced his daughter, the petitioner, to file the I-130 petition earlier than 10 months after she turned 21 years old. Quote, "After all, Mr. Combe had been staving off deportation for over 3 decades, and he was well familiar with the I-130 petition process by the time his daughter turned 21. End quote. Mr. Combe, therefore, lost his case. Just want to highlight one more thing. On the jurisdiction continuance stuff, while other circuits may come around to this same holding, that is, that they don't have jurisdiction because of Patel, they may not. And keep in mind that your circuit might have precedent that has been read to require granting a continuance where USCIS has a pending I-130 petition before it. For example, an immigration judge would presumably be separately bound by such a rule, as would be the BIA, and so kind of would have to grant a continuance where an I-130 petition was pending before USCIS, at least where it's prima facie provable. One such case out of the 11th Circuit, for example, would be Bull v. INS. And that is a Combe v. Bondi. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025. That's IMMREVIEW2025. Keep up and join the good fight. Welcome back with Porter v. Bondi, published by the 6th Circuit on January 24th, 2025. This case is about drug trafficking aggravated felonies as defined at INA Section 11A43B. It was actually issued on January 24th, but the court didn't designate it for publication until February 10th, hence a This Week case. Mr. Porter's from Jamaica and was a lawful permanent resident for a while. Until, that is, he was convicted under Virginia law of possessing with the intent to distribute methamphetamine in violation of Virginia Code Section 18.2-248. 200 grams alleged as well. I'm no meth person anymore, but that sounds like a lot. And Mr. Porter pled guilty in part because the prosecution agreed to strike the weight amount from the indictment. So, it's simply a struck allegation, everyone, that 200 grams. A 4-year imprisonment was ordered. DHS, however, alleged that it made Mr. Porter removable because the conviction is an aggravated felony, which of course makes LPRs lose their LPR status if true, DHS's burden. And an IJ and the BIA believed that it was met. It is quite complicated and a very complicated week. That is the INA Section 11A43B analysis, so let's get into it. Because the 6th Circuit agreed with the agency and affirmed removal. 101A43B defines as an aggravated felony, quote, illicit trafficking in a controlled substance, as defined in Section 802 of the CSA, including a drug trafficking crime, as defined in Section 924C of Title 18, end quote. Reducing that down further, explained the Sixth Circuit, quote, the term controlled substance is defined as a drug or other substance included in Schedule 1, 2, 3, 4, or 5 of the subchapter, end quote. That is 21 U.S.C. Section 802.6. And that's usually the focus of these cases, is the drug in question covered by the Controlled Substance Act, the CSA, the statute I just read, which lists the federally controlled drugs. Now, drug identity aside, recall there were two portions of that AgFel definition, illicit trafficking and a drug trafficking crime. Quote, a drug trafficking crime means any felony punishable under the CSA. End quote. Or two other statutes not relevant here. And a, quote, felony is an offense for which the maximum term of imprisonment authorized is more than 1 year. End quote. Mr. Porter's first argument was that a state offense can't match this definition if the quantity trafficked is undetermined, as of course it was here because remember, they struck the amount in the plea negotiation. And true, one of the drug trafficking crimes under the CSA does reference a 5-gram threshold for methamphetamine crimes. But to the BIA and the Sixth Circuit, that's simply an enhancement provision. More punishment for having 5 grams of meth or more, it seems. But meth is a Schedule 2 and a Schedule 3 offense, depending on its form, and trafficking in any meth is still a Section 924 offense, explained the Sixth Circuit. So the fact that the quantity is not known in the conviction is of no importance. It still seems to meet the definition of a drug trafficking crime as defined in Section 924C as the aggravated felony provision requires. It does still beg the question, though, was Mr. Porter's state conviction punishable as a felony as that term is understood under the CSA? If it's not a Section 101A43B aggravated felony. It's the categorical approach, and it requires an analysis of a few things. First up to the Sixth Circuit, the drug in question. I suspect that Virginia criminalizes trafficking in more substances than does the CSA, so if the drug in question isn't an element of the offense in Virginia, Mr. Porter's going to win. Well, the Sixth Circuit agreed with the BIA, which in turn relied on the best-named decision from 2022, matter of Dingus, episode 104, to hold that the identity of the controlled substance at issue in Virginia is an element of the offense, making the statute divisible. That means that the court can look to the conviction documents and see that Mr. Porter trafficked in methamphetamine, which is a covered CSA drug. The Virginia statutes are not, as Mr. Porter argued, divisible both to identity and weight. If it was, there might be a categorical approach problem, which is of course what Mr. Porter wants, but it is not, explained the court. Because again, the CSA makes it criminal to traffic in any amount of meth, said the Sixth Circuit. That, plus the 5-year imprisonment ordered, makes this a CSA qualifying felony. This is a very complicated and at points quickly written decision. Give it a read, 101A43B analysis is very complicated. And lots of other very smart arguments were swatted down all over this one. I'm sure the briefing was mega complicated. For example, Mr. Porter argued that his crime didn't match the aggravated felony definition because it can be done without the exchange of money, through simple unlawful trading or dealing, it seems. An argument that I believe has legs in at least the 11th Circuit. Well, here, the Sixth Circuit rejected it, because there is more than one way for a state offense to be a drug trafficking aggravated felony. Mr. Porter's argument is the one focused on the illicit trafficking portion of 101A43B, which does indeed require a monetary transaction element, it seems. But the other way is to simply match the Virginia offense to a CSA drug felony. And as previously discussed, Mr. Porter's conviction met that. Very complex stuff. Mr. Porter also made an isomer-type argument akin to that accepted by the 2nd, 7th, and 8th Circuits recently, at least if my memory serves, but it seems like he might not have made it until the petition for review stage and not developed it enough. While the 6th Circuit rejects it, I'd try the argument again in the 6th Circuit. Because procedurally, the 6th Circuit essentially deemed the argument waived rather than outright rejecting the concept of overbroad isomers and analogs, and all of that stuff. If you know, you know, crimmigration folks. Other arguments summarily rejected, and Mr. Porter was deemed removable. And that is Porter v. Bondi. Two cases from the First Circuit this week. Let's go to the quicker, easier one first. That's Sanchez-Alves v. Bondi, published by the First Circuit on February 12th, 2025. It's a very short case about asylum, and it's authored by none other than retired U.S. Supreme Court Justice Stephen Breyer, who it is known will sometimes sit on his old circuit's panels, I suppose, whenever he feels like it. He felt like it here. This case is about Miss Olimpio, her husband, and their child, who applied for asylum in removal proceedings. Stated summarily, Miss Olimpio, quote, alleged that in Brazil, she had suffered abuse at the hands of her ex-partner, end quote. The IJ and the BIA held that that was more of a personal dispute, rather than harm or fear of harm on account of a protected ground, race, religion, nationality, political opinion, or membership in a particular social group. No nexus. The retired Associate Justice and his colleagues agreed with the agency. To the court, Miss Olimpio, quote, testified that the first time her ex-partner hit her was when she left him and went to stay with her father, and that he threatened her when she refused to return. In short, the evidence in the record does not compel a finding that the scope of any persecution extends beyond a personal vendetta, end quote. And honestly, guys, that's it. That's like the whole decision. The family lost their case. I propose nothing. I wonder who serves as a law clerk to a part-time retired associate justice riding the circuit, and how one gets that position. And while we're with the First Circuit on this very short case, congrats to ACLU New Hampshire and the many, many, many others on obtaining your preliminary injunction against Mr. Trump's unconstitutional citizenship executive order. And that is Sanchez-Alves v. Bondi. Alright then. Moving on to Fimadi v. Bondi, published by the First Circuit on February 10th, 2025. This case is about motions to reopen. Mr. Fimadi entered the United States at 2 years old in 1979 as a refugee from Laos. He of course grew up in the United States, primarily in Lowell, Massachusetts. But in his adolescence, he joined a gang in Lowell, in part because he himself had previously been a victim of gang violence. At 15 years old, he was charged with gang assault in juvenile court, but the matters were transferred to Superior Court, it appears, actual criminal adult court. Pretty bad stuff, too. Armed assault with intent to murder, conspiracy, and armed robbery. Gang life. He pled guilty in 1993 and was sentenced to over a decade in prison. And while in prison in the 1990s, former INS initiated deportation proceedings against him and obtained a deportation order. But Mr. Fimadi is still here, having been on an ICE order of supervision ever since his release. And since then he has, quote, rebuilt his life, end quote. For example, quote, only 8 days after his release from INS custody, he obtained a position at Hologic Incorporated and remained employed there for 17 years. He currently works as a manufacturing manager at Belmont Medical Technologies. Mr. Fimadi also married and started a family. He has 3 children who all attend Lowell public schools. Since being released in 2000, Mr. Fimadi has not been charged with any crimes, end quote. Those in the know that there are lots of people like Mr. Fimadi in the United States. Boat people or other refugees from the U.S. wars in Southeast Asia, primarily Vietnamese, Laotians, and Cambodians, who came to the U.S. as refugees, as children, and settled in New England, but were settled in rough areas. As I understand it, partially as a result, Southeast Asian-based gangs developed, and a lot of these guys got swept up into them. But the U.S. wasn't deporting people to these Southeast Asian countries for years because we didn't even recognize some of their governments. And in the interim, lots of these people transformed their lives. So what do we do with them? The Trump administration began targeting them for removal during the first Trump term because they are low-hanging fruit. People with criminal convictions, albeit decades old, and with deportation orders who comply with ICE and regularly check in and so can be picked up pretty easily at their check-ins. I can only imagine that pattern will recommence soon. Looks like Mr. Fumati survived the first Trump term and wasn't going to wait around for a second. In 2022, he successfully got his 1994 convictions vacated, quote, because the judge who presided at his plea hearing did not provide him with a warning about the potential immigration consequences of his plea as required by Massachusetts law, end quote. Required by federal law too, by the way. Then, the prosecution null-prossed the charges. So Mr. Fumati has no criminal convictions in the United States right now, meaning he'd revert back to refugee status and even be able to become a lawful permanent resident. Except for that pesky 30-year-old deportation order. What to do? Gotta file a motion to reopen, here, with the BIA, because Mr. Fumati appealed his deportation order all those years ago. Now, I'm not gonna lie. There might have been a way to argue that this motion to reopen should be statutorily based. Yes, they must file within 90 days of the deportation order, but that time can be equitably told, and here the argument would be that it should be told up until the convictions were vacated. Not saying it would win, but it's possible. Mr. Fumati did not make that argument, and that's a rational choice. Instead, he asked the BIA to exercise its sua sponte authority to reopen, really just asking the BIA to be nice. The problem with bringing a sua sponte motion to reopen, though, is that there's a whole bunch of case law that says it's pretty standardless, and so, if the BIA denies, you can't petition for review. To paraphrase, a lot of law. The BIA did just that. It said, no thanks, we decline. Mr. Fumati then filed a motion to reconsider that denial, arguing that, quote, the BIA's decision in this case was at odds with its long-standing and well-settled practice of concluding an exceptional situation exists warranting sua sponte reopening, whenever a non-citizen demonstrates that the conviction underlying their removal order was vacated due to a defect in the criminal proceeding, end quote. That is what happened here, right? The conviction was vacated because of a procedural or substantive defect, a constitutional violation of not warning Mr. Fumati about the immigration consequences. But how to show that? That is, that the BIA has this standard practice. Well, Mr. Fumati attached no less than 92 unpublished BIA decisions in which he asserts that the BIA was doing just that. But the BIA was unmoved, literally. It didn't like how long Mr. Fumati had waited, believed his conviction had been vacated on a, quote, technicality, end quote, sometimes referred to as a constitutional violation, and noted how egregious the facts of his plea were all those years ago. So it all went to the First Circuit, which affirmed the BIA, after barely finding it had jurisdiction at all. As I mentioned, often the circuits find they don't, at least with a sua sponte motion to reopen review. But even with sua sponte motions, quote, when the BIA's denial rests on a legal error, it is appropriate to remand to the BIA so it may exercise its authority against the correct legal background, end quote. Hence the argument that the BIA was violating its own settled course of practice of granting motions to reopen when a conviction is vacated for a substantive or procedural defect. And actually, as the First Circuit so often does, it bypassed the jurisdictional stuff because it and the motion rose or fell on the same question to the court. Does the BIA even have a settled course of practice? It does not. The BIA sure hasn't said it has one, or really any standard for sua sponte reopening, just that it's for, quote, truly exceptional situations, end quote. Nor are there any precedential decisions, at least that the First Circuit could see, where the BIA flat out said that conviction vacature is truly exceptional. I'll tell you what though, with what the BIA is doing, moving the goalposts every few months on how to properly get a conviction vacated and then recognized for immigration purposes, and how to prove a procedural or substantive defect, it might become truly exceptional in the not so distant future. Zinger, Kevin. Straight zinger. Anyway, though, what about those 92 unpublished decisions? In the First Circuit, after all, the court will consider, quote, unpublished decisions in determining whether the BIA has established a settled course of adjudication, end quote. A couple of those recent First Circuit cases can be found on the podcast page. Well, as so often occurs, those 92 decisions reopening after a conviction is vacated say some different things. Some were simply based on DHS's non-opposition. Some simply mentioned the totality of the circumstances, as quite frankly the BIA always seems to do. Some of those decisions additionally depend on the non-citizen's diligence in getting their conviction vacated, not present in Mr. Famati's case to the court. The First Circuit just didn't see a settled course of practice. Quote, although several outliers may not be enough to defeat a settled course of adjudication claim, end quote, the First Circuit didn't see any settled adjudication practice to begin with. The BIA is all over the place on sua sponte motions to reopen, which here destroys Mr. Famati's argument and the jurisdictional basis for him to seek review of his sua sponte motion to reopen denial. Say that 5 times fast. And I don't know, though. Seems like you could read this decision and the government's argument as supporting a settled course of granting such motions when the BIA finds that the non-citizen has acted diligently in getting his conviction vacated. Give it a read and tell me if you agree. Legalese and ivory tower analysis aside, all of this means that Mr. Famati is at risk of removal to Laos nearly 50 years after being brought to the U.S. as a refugee at 2 years old because of some very unfortunate convictions obtained at 15 years old, where the state of Massachusetts then decided to charge Mr. Famati as an adult, and notwithstanding the vacature of those convictions, for constitutional reasons, and apparently Mr. Famati's reformation into a pretty good person. And that is Famati v. Bondi. If you're still with me, you are the true champion. We conclude with Perez-Perez v. Bondi, published by the 8th Circuit on February 14th, 2025. It's quite the unique case about asylum. Mr. Perez, his wife, and their 2 children are asylum seekers from Algeria, and the story really concerns one of the children known as TF in these proceedings. TF has the tragic condition of spina bifida. Before birth, doctors told the family that TF had a fatal condition, took the mother to an unknown location, removed TF from the womb, and then didn't tell the mother what had happened to TF. I suppose then, immediately post-C-section, she, quote, searched the hospital for TF and found him in an abandoned ward, wrapped in a sheet on a countertop, end quote. Having rescued her baby, neurosurgeons then refused to treat the spina bifida condition, even though there are treatments. Of course, the condition worsened, and eventually it was recommended that they seek surgery abroad, which apparently requires approval from the Ministry of Health, at least if the Algerian government's going to pay, and the president of Algeria's Neurosurgery Society agreed to seek that approval. But then he revoked the offer, saying that they could do it in Algeria. But then he said actually, his schedule to do the surgery was full. No surgery. The family even contacted the sister of Algeria's president, who found a doctor who could sign the approval for surgery abroad, but then, quote, the recommended doctor refused to sign the form and claimed that he would lose his job if he did because authorizing the treatment was contrary to Algeria's policies of treating spina bifida domestically, end quote. You see, as I kind of mentioned, apparently, under Algerian law, if it's recommended that an Algerian individual go abroad for surgery, the Algerian government must pay for the treatment, meaning that stuff like this is often refused because it's very expensive, it would appear. So the family turned to a GoFundMe type strategy. What a world we have. And you know what? Through YouTube exposure, they actually raised $130,000. Rock on. The whole thing also got the attention of a pretty high-profile Algerian doctor in Minnesota who, essentially, it would seem, helped TF get into a free treatment program at the Mayo Clinic. So the family made plans to come to the United States. But before they could, TF's condition worsened, requiring emergency surgery in Algeria, which a doctor postponed, quote, so he could bring in other doctors to make a case study out of TF's rare case of spina bifida, end quote. Horrific! Because 1 week later it all ruptured and TF nearly died. Finally allowed to come to the US, very emergency-like, the Mayo Clinic stabilized TF and his condition has improved. Mr. Perez actually works for the Algerian Ministry of Religious Affairs, but was fired when he remained in the United States. The couple's oldest sons remain in Algeria, studying. So there's your facts. The asylum claim was based on the asserted past persecution and a fear of future persecution based on the family's membership in the asserted particular social group, quote, parents of a person born with spina bifida, end quote, while TF sought asylum as a child with spina bifida. Imperfect system, asylum and immigration law in the United States. An IJ and the BIA didn't believe that what had happened to TF and the parents was past persecution. Lack of resources in Algeria at most, and not because of any animus towards spina bifida people or their parents. Nor did the IJ or the BIA believe that there was a reason to fear future harm in Algeria for exposing how bad spina bifida children are treated there. Plus, the other sons still live in Algeria, unharmed, reasoned the agency. Now true, mixed motive cases are alive and well in the Eighth Circuit, quote, persecution may stem from a mixed motive, and a finding of a particular motive does not preclude a finding of additional motives that may concern a protected ground, end quote. Plus, inadequate medical care can constitute past persecution. But the Eighth Circuit affirmed the agency, because also a, quote, absence of a nexus between the conditions and a persecutory motive negates a finding of inadequate medical care as persecution, end quote. Here, for example, even Mr. Ferchichi testified that it's pretty hard for everyone in Algeria to get medical treatment, and many Algerian doctors simply don't have the expertise. Nor did the Algerian government prevent TF from leaving the country. They just refused to send him, given the expenses involved, reasoned the Eighth Circuit. Tragic, but not past persecution. As to a well-founded fear of future persecution, and despite the fact that police have asked about the whereabouts of the family since they left, the older sons still live in Algeria unharmed, reasoned the Eighth Circuit. At most, the court sees a fear of mere harassment, which is not a fear of persecution. To the extent the country condition evidence shows bad conditions in Algeria in some contexts, the court sees, quote, no link between the country conditions reports and the Ferchichi family, end quote. But remember, country condition evidence can win the day in the Eighth Circuit if sufficiently tied or germane to the asylum applicants. Here, though, quote, speculative and otherwise doubtful, end quote, that the Algerian government will take retribution on the family, reasoned the court. Meaning that the family lost their case. And that is Ferchichi v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.